Hello everyone, welcome back to the Let's Dream Civils YouTube channel. Today we are going to discuss about an important constitutional current affair. Recently, Punjab and Haryana High Court suspends ex-CBI Court Special Judge. From UPSC perspective, we will see who controls the subordinate judiciary, what is Article 235, how is judicial independence is protected while ensuring the accountability. This topic is important for GS paper 2 and 4. The news context. On May 29, 2026, the Punjab and Haryana High Court placed the judicial officer Rajiv Goyal, the former Panchkula CBI Court Special Judge, under immediate suspension. The formal order was officially promulgated by the High Court's Registrar General under administrative protocols. One important thing to notice here is the suspension order was issued by the High Court's Registrar General, not by the state government. Now, many students may ask, isn't the governor responsible for judicial appointments and dismissal? The answer is yes. But the thing is, appointment and dismissal and the disciplinary controls are two different constitutional powers. Whereas the appointment and dismissal power vests with the governor and the disciplinary control power vests with the High Court. The key legal dimensions here are the suspension was executed because of initiating a disciplinary proceeding. Okay, and then the specific reasons were not publicly disclosed because the disciplinary proceedings will remain confidential until the investigation is completed. But the action strictly pertains to the period when he was proceeding as the special judge of the CBI court in Panchkula. What does this mean? Because we saw in the headline itself that he is an ex-judge, right? So the High Court has power to proceed with a disciplinary action over a judge for their professional misconduct or any corruption, even though they are not currently holding the office. Now let's see the Article 235 of Indian Constitution. Why? Because Article 235 vests the complete power of control over district and subordinate courts in the respective state high court. So, what is the complete power of control that we are talking about? This control encompasses absolute disciplinary jurisdiction over persons holding any post inferior to the post of district judge. This is very important. Article 235 provides the control over the persons holding any post inferior to the post of district judge. Okay, so what is the absolute disciplinary jurisdiction that we are talking about? It is posting, promotion, leaves, and the power of suspending judicial officers pending the formal inquiry. Okay, this ensures the complete insulation from the executive interference or political interference. Understanding the CBI courts. What is a CBI court? The CBI special courts are established to try the cases investigated by the Central Bureau of Investigation under the Delhi Special Police Establishment Act 1946 and the Prevention of Corruption Act 1998. So these are not tribunals. So CBI special courts are just like the standard session or district level courts. They are not tribunals. Okay, they handle the cases which are investigated by the CBI. Okay, and the judges for the CBI special courts are selected from the state judicial service only in active consultation with the High Court. Okay, now let's see the Panchkula jurisdiction. The CBI court in Panchkula, Haryana holds absolute jurisdiction to hear all the CBI registered cases across the entire state of Haryana. So what is the point to be noted here? That even the cases they hear or the cases investigated by the central agency, that is CBI, these judges remain under the disciplinary control of the state high court. Okay. Now let's see the independence versus accountability. How are we safeguarding the judicial independence? Under Article 50 of Directive Principles of Indian Constitution, the state must separate the judiciary from the executive. How are they separating it? By vesting the disciplinary authority solely in the High Court rather than the state government. Therefore, the Constitution prevents the executive intimidation of judges. What does that mean? Imagine if the disciplinary authority is solely vested with the state government, then the judges may fear of suspension by the politicians while handling the cases related to them, right? Then what is the guarantee that they will provide judgments independently, which will be fair. So, to provide a constitutional shield for the judges, the disciplinary authority is vested with the High Court rather than the state government. So, when they are completely independent, how we can enforce the accountability? So, judicial independence is not absolute. It does not protect the judiciary officials from corruption or professional misconduct. It protects the judiciary officials from the intimidation of any legislator or by the government, but it does not protect them from the corruption or professional misconduct. So, the disciplinary action by the High Court represents internal self regulation to preserve the public trust over judicial system without yielding to political and executive control. So, how this disciplinary action will be taken step by step? Step 1 will be intake. The complaints or negative vigilance reports are received by the High Court's registrar. So, the complaints may come from citizens, come from judicial officers, come from the vigilance officers. Okay. First, they will receive the complaint. Then, step 2 will be enquiry. A preliminary enquiry will be ordered by the Chief Justice of the High Court. Mostly, the enquiry will be led by a designated senior judge. And then comes the suspension. If prima facie guilt is detected, prima facie means at first sight. So, prima facie guilt, if there is sufficient material to say that there is some misconduct has happened, then the full court suspends the officer pending the final trial, and then comes the action. When the enquiry is completed and the enquiry reports leads to the recommendation of dismissal, that they have confirmed there is a corruption or a misconduct has happened, then the final dismissal will be issued by the governor. This is very important. Who has taken the disciplinary action? High Court. But who will issue the dismissal after the final report? Governor. Because we all know judicial appointment and dismissal, the power rests with the governor. Thank you so much for watching the video. If you find this video helpful, kindly share and subscribe to the channel. Thank you. Stay tuned.